I have the great pleasure of interviewing Brigid Maloney this morning. She is a partner and the co-leader of the health law practice at Mathias, Wexler, Friedman in both their Buffalo and Albany offices. Good morning, Brigid.
Hey, Missy, how are you today?
I'm well, thank you. How are you?
I'm well. Thanks for having me.
Yeah, thanks for your time. You have quite the impressive background. So over 20 years of healthcare law. And, before this interview, I decided I better get reacquainted with your bio. And I thought, I don't know, there's an area of healthcare that you actually don't cover. Am I right?
I think when you've been practicing an area of law as long as I have, you touch on just about everything. And health law is vast. It's a heavily regulated industry, but
for sure.
I've been lucky enough to encounter a wide variety of clients.
That's great. I'll be sure to put a link to your bio in the video description, and I hope definitely the viewers will go there and take a look. But I mean, you had everything from technology to health systems, hospitals, and medical practices, and everything in between. So certainly, if anybody needs some healthcare guidance, you are the one to call. There's no doubt about that. And who better than for me to be able to have some time this morning and ask these questions? I appreciate it. Thank you.
It's my pleasure to be here.
So Brigid, I regularly hear the woes from physicians who relent about the things they wish they knew before signing an employment or a non-compete agreement. And honestly, it's really an example of multiple areas that they wish they knew back when that they know now. So I had started this video series thinking, all right, we got to get this info out to these younger physicians, or enough info to give them some guidance, and from there then call experts like yourself, to get them the rest of the way. But particularly those in residency or just coming out of residency, which is great timing right now for that. So I put together a few questions of the ones that I often hear, nothing too painful. So are you ready to get started on these questions?
I sure am, Missy.
All right, great. Is it necessary to involve an attorney for the review of an employment agreement?
I'm so glad you asked this question. The answer is yes, yes, yes. It's important for physicians to get an attorney involved as early in the process as possible. In fact, sometimes larger employers won't begin with the employment agreement. They'll start with a term sheet or a letter of intent, and the document will often say non-binding, and it will give the physician a sense that they can sign this without having an attorney review it first because it's non-binding. What's the big deal? Well, those preliminary documents are actually a very big deal because they set the stage for the larger negotiation, and they generally represent a meeting of the minds between the physician and his future employer on big deal issues like compensation and term of the agreement. So yes, please, physicians should get attorneys involved as early as possible. I get two kinds of calls from physicians asking me on the front end to take a look at their employment agreements. And frankly, it's not just me. We have a large employment law team here at Mathias, and they deal with employment agreements in all industries. So I work very closely with Amy Habib and Vinnie Miranda in our office anytime an employment agreement question comes in. But so the first batch of calls we get are physicians who are at the beginning of the process, and we really enjoy helping them navigate through the issues that they're confronting when they're taking a look at their first employment agreement. The second batch of clients we hear from are physicians who didn't work with an attorney on the front end and maybe want to make some changes or leave employment and don't really understand the terms that they agreed to at the beginning of their arrangement. Some of the issues, Missy, some of the most frequent issues that come up, and I'm sure you hear about this in your business as much as we do in ours, are important topics that physicians don't realize are important when they're at the very beginning of their careers.
Well said.
And these are things that may be addressed in the employment agreements or things that have been left out that should have been addressed. And I'll start with some simple examples if you'd like, and
Sure.
then
Yeah.
get into some headier stuff.
Yep.
A simple example is an emergency room doc or an internist who is just starting out, is feeling the heavy weight of their student loans, and they're wanting to do some moonlighting on the weekends or holidays to pick up a few extra bucks to offset their
Yeah.
heavy debt load.
Yeah.
A lot of physician employment agreements expressly state that the physician may not work anywhere else
Sure.
without the employer's permission. And sometimes if they do, their malpractice coverage won't extend to that
Yeah.
per diem work. So they're putting themselves at risk, possibly from a malpractice perspective, and they're also putting themselves in breach of their employment agreement, which could result in them getting fired.
Yeah.
So the outside activities or no moonlighting provision is one that is sometimes overlooked, but it's very important.
Yeah, no, that's a great point.
Another one that we hear about frequently relates to call coverage. So great example, young physician comes into an established group with more senior physicians.
Yeah.
The agreement speaks to call coverage or it doesn't. If it does speak to call coverage, it says in a very cursory manner, the physician's expected to take on call coverage responsibilities. What the young physician doesn't realize, if he or she is joining a group with 5 or 6 or more other physicians, the physician may sometimes assume that the call coverage will be proportionate, thinking,
Sure.
oh, 1 out of 7 weeks, I can do this. When in reality, the senior physicians often are choosing not to take call anymore.
Yeah.
And so the entire burden is placed on 1 or 2 junior physicians. So that's an important term to negotiate on the front end.
Most definitely. Yes, absolutely.
Another area that can cause problems for physicians, and certainly this is a quality of life issue, is the location of the practice. So if a physician joins a practice that has multiple sites and their expectation is that they'll be reporting to work at an office, for example, that's near their house every day, and if the agreement doesn't specify the location of their work and doesn't specify that they won't be moved to a different location without their permission, then a physician can end up being assigned to work in an office that's 45 minutes or an hour away from where they were expecting to work.
Yeah. Yeah.
And that comes up time and time again. Compensation, it is always complicated. So a lot of times, initially, physicians will be paid a guaranteed base salary for a year, 2 years, if they're really lucky, 3 years.
Sure.
But after that term of guaranteed compensation expires,
Yeah.
then their compensation is going to be dependent probably on their productivity. Their productivity is probably going to be calculated based on WRVUs.
Yeah.
And things can be difficult for a young physician to understand if they haven't worked in the world of RVU calculations yet. And most young physicians haven't. So it's important for a physician to understand how they're going to be paid, what they need to do to reach the level of compensation that's important to them, and what the industry standard is. So an attorney that works regularly with physicians has seen hundreds of physician employment agreements from hundreds of employers, and we have a pretty good idea of what's standard in the industry.
Sure. Yeah.
An example of that is RVU productivity. So how many RVUs would the average OBGYN, for example, be expected to produce in a given year?
Right.
That's important to know, because once the physician has a rough idea of that number, they'll know what the threshold would be appropriate for to earn bonus or productivity-based incentive compensation on top of that. In other words, it's nice for the physician to know what the baseline expectation is and how much they'll need to work, how much effort it will take to get those extra bonus dollars.
For sure. Yeah, well said. Yep, absolutely.
And I've got a couple of other clauses that I think I'd like to, if I've got another minute or two, that I'd like to draw
that'd be
your
great.
audience's attention to. One is indemnification clauses. So an indemnification clause is where a party to a contract says, if the other party incurs losses or
Mhm.
expenses, costs, attorney's fees as a result of something I've done, then
Mhm.
I will personally cover those losses for that party. I will cover the attorney's fees. I will pay any fines that are caused by it. Indemnification clauses are really common in corporate transactions where we're
Sure.
dealing with entities with deeper pockets. But when an employer asks an individual physician to indemnify the employer for losses associated with something related to what the physician has done, we really need to look carefully at that clause to make sure, if it needs to stay in the agreement, that it's
Mhm.
written in as narrow a
Sure.
fashion as possible,
Yeah.
because these are real dollars that can add up quickly, particularly if we're talking about compliance-related fines and any kind of attorney's fees.
Sure. That
And
makes good sense.
indemnification clauses are not written in ways that lay people can readily
Right.
understand.
Yeah.
So that, I
Yeah.
think, is probably a red flag issue that
Okay.
every physician should be aware of before they enter into an agreement.
Yeah. Excellent point. Yeah. Absolutely.
Another issue that's very important relates to malpractice insurance. So when a physician becomes employed, generally the employer will obtain and maintain a valid malpractice insurance policy on that physician's work. And that's great. And that's
Mhm.
usually a cost that's incurred by the employer.
Sure.
The issue is there are two kinds of malpractice policies available.
Mhm.
There's a claims made and an occurrence-based policy.
Mhm.
An occurrence-based policy means the policy will cover the acts of the physician during the time of the policy coverage, for example, during the term of the employment of the physician, and later, even after the employment ends, regardless of when the malpractice claim is filed. So as long as the action relates to something that occurred during the term of the policy, the term of the employment, the occurrence-based policy will cover it.
Mhm.
That's great.
Yeah.
A claims-made policy is a little bit narrower and it doesn't provide quite as much protection for the physician. A claims-made policy covers the acts of the physician, but only for claims that are filed against the physician during the term of that policy or during the term of the physician's employment with
Yeah.
that employer. That means when the physician leaves employment and is no longer covered by that policy, if a patient files a claim for malpractice against that physician for something that occurred during their time with the employer, that claims-made policy isn't going to cover it.
Yeah. Yeah.
So the way a physician protects himself or herself after a claims-made policy has expired
Mhm.
is to obtain so-called tail coverage.
Yeah.
And
Yeah.
this is the coverage that covers the period of time after the claims-made policy is expired. The problem is tail coverage can be very, very expensive
Yes.
for certain
Yes.
specialties. So
Yeah.
it's important for a physician in their employment agreement at the very beginning of the arrangement to make sure that he or she understands what kind of malpractice policy will be obtained to cover the physician's work. And
Yeah.
if it's a claims-made policy, who's going to cover the cost of the tail coverage? And I'll
Yeah.
tell you right now, Missy, some of the time the employers agree as a benefit of employment to cover that tail policy. Other times employers, for financial reasons or otherwise,
Yeah.
elect not to cover the tail coverage.
For
And
sure.
that is a difficult surprise for a young physician to encounter when they leave employment and they're making arrangements for their next move to find that they've got to manage a tail coverage expense.
Like as much as $50,000 tail coverage.
Yeah, you've seen
Yeah.
it with your clients, haven't you?
Yes. Yes. That's what's so interesting about everything that you have shared. I have seen. I was thinking in my head of scenarios that I've witnessed. So they're really happening. These poor physicians. They just, like you said, they really just didn't know any better. They signed it. They're excited. And then later on, there's a reason, there's something, whether it's call coverage abuse, tail coverage. I mean, I've seen it, and all the above.
Yeah, and I don't think that this is something that is purposeful on the part of
Sure.
employers. For the
I
most
agree.
part, the majority of employment agreements we review for physicians are written in a really fair way. The
Yeah.
problem comes with the physician's lack of understanding of what they're getting into.
Agreed. And to that point, I would say sometimes too is they have an employment agreement that they give them that they've just had for years. Nobody has scrubbed it for years, and none of them really even know exactly what's in there. It's been a long time since they ever really took a look at it. So they just give it to this new incoming physician, and there's no real discussion now about what this means and today, tomorrow. And so I agree with you. It's not always really with malicious intent.
Yeah, yeah. And the last and biggest, and maybe
Yeah,
you and I can talk about this in a more detailed way, is the
yeah.
dreaded non-compete covenant.
Yes, that was actually my next question. What is it? Should I sign it? Yes.
This is a biggie. I think this is probably the biggest physician employment agreement issue at
Yeah,
hand. And if your viewers take one thing away from our discussion today, this is the segment that they really need to be listening to.
for sure.
So what is a non-compete agreement or a non-compete clause or covenant? It's a clause included in a physician's employment agreement that states that during the term of the physician's employment and for some period of time after they leave
Mhm.
employment, the physician will not work for a competitor, will not provide medical services at a place that is competitive with the employer. They won't start up their own practice within a certain geographic area.
Sure.
And non-compete agreements can be complicated, and they can have long-term effects on a physician.
For
So
sure.
for example, if a physician enters into an employment agreement, doesn't pay attention to the non-compete, decides it's not working out in a few years, and gets job offers from other health systems in the area, for example, there is a good possibility that the physician won't be able to leave employment with their current employer and join another medical practice or health system
Yeah,
because the non-compete language in their employment agreement prevents them from doing that for some period of time,
yeah,
typically a year or 2 years, sometimes even 3 years.
yeah.
So a lot of the calls we get are from physicians who would like to leave their current employment, go work for a competitor system, for example, and want to know if they can get out of their non-compete agreement or if the thing is even enforceable in court.
Yeah, yeah.
High level, generally speaking, non-compete clauses are indeed enforceable against physicians in the state of New York.
Okay.
That's the general rule. But there are a lot of asterisks to that
Yeah,
rule. The non-compete clauses are only enforceable if they are reasonable in terms of geographic area. So an employer can prevent you, under the right circumstances, from going and working for a competitor within a 5-mile radius,
sure.
possibly a 10-mile radius. In rural areas and other parts of the states, we've seen a 50-mile radius.
Wow. Wow. I was gonna say 30, but wow, 50. Oh my word.
Yeah. We haven't tested that one in court yet. So the
Wow.
question of whether or not it's enforceable is a very good one. The
Yeah.
other thing is, in addition to being reasonable from a geographic scope perspective, the non-competes are only enforceable if they're reasonably limited in time. So again,
Okay.
a 1 year, a 2 year, possibly a 3 year non-compete is potentially enforceable. A 10-year or an unlimited non-compete, probably not. And the scope of the non-compete needs to be reasonable as well. So a family medicine is probably not the best example here. An anesthesiology practice, a specialty practice, can prevent a physician from going and practicing anesthesiology in a narrow geographic area for a limited amount of time. But if the anesthesiologist also happens to be double boarded in another area that's not competitive with the anesthesiology practice, the anesthesiology practice can't necessarily prevent that physician from going and practicing another kind of medicine that doesn't directly compete with the anesthesiology practice.
Okay, gotcha.
But here's the thing, Missy. Even if a non-compete clause is written in a way that's overly broad, or it looks like it's not enforceable because it's not reasonable in terms of time, geographic area, or scope,
Yeah.
it still can be very, very expensive for the physician to
Sure.
fight about it.
Sure.
So you have an unenforceable clause in your agreement, and your lawyer can tell you that's not enforceable. If we went to court and fought over it, we would win.
Sure.
The cost of getting there
Right.
is
Yeah.
very high. And so
Yeah.
we prefer to not have to challenge non-competes if we don't have to, and
Yeah.
address the issue of the non-compete clause at the beginning of the employment rather
Yeah.
than when the physician is thinking about leaving.
No, that makes perfect sense. You know, I actually had a client physician, she signed a non-compete. It was 3 years and 30 miles. So she wanted to leave there, wanted to start her own practice. Initially, she found a location that she liked. It was 28 miles away, and he still was going to fought it, still fought it. And so she ended up finding then one that was the 30-mile range. And, you know, that was what her attorney had advised her, that you could fight it and you'd probably win, but do you want to spend all that time and money to do that? You know, because he was the type that definitely would have fought her as well. I guess that he would have dragged it, you know, through court. And if she had only ahead of time had that reviewed, she could have saved a lot of headaches.
Yeah, yeah. And getting an employment agreement reviewed on the front end does not have to be a complicated or
Sure.
expensive process. In fact, each year I give a talk to a residency group associated with the University of Buffalo. And I invite the young residents, when they begin to get their employment offers, to call our office. We quote them a flat fee, and for that fee, we'll review the employment agreement, take phone calls, answer all of their questions, type up a memo for them, identifying important points, and assist them with negotiating the right terms for those employment agreements.
I love that. That's great. That's great that you're doing that. I'll make sure to put that also in the description, just as a reminder to these young residents. And hopefully beyond the University of Buffalo, we'll get an attraction as well.
Thanks, Missy. I appreciate that.
Yeah, no problem. So you did answer my third question, was once employed, is it enforceable? That was my other question. So I do have one final very tough question for you. Where's your favorite place to eat in Buffalo?
Oh my goodness, there are so many.
Right? See, this is a tough question.
So many. Well, I'll tell you where I'm going to lunch today. By hands down. Well, I've got two favorite lunch places, and I've got to give them both shout outs.
All right.
Feature is across the street from us on Chippewa, and it's a counter of organic, super healthy grains and greens, and keto friendly for those of you who are into keto. Yeah. And Michael and Justin are the proprietors, and they're right there serving up your food as you order it as you go. So Feature is super cool. But my sit-down place with the white tablecloths for lunch, Frankie Primo, is up here on Chippewa also. Yes,
I just had lunch there with some colleagues a couple weeks ago. It was great. It was nice enough to be outside. You know, it was so good. Yeah, I have to agree with you. Good place.
And that Chippewa corridor during the lunch hour during the week is so much fun. There are so many businesses that have access to it for lunch.
I agree. It's so funny. I was just talking to a colleague about that. They're in the Seneca downtown building, and they love going to eat for lunch on the Chippewa Strip, because they're like, you will see just about anybody there at any point. Like that day, Paul Simonelli walked by when we were there, you know, so you just never know who's going to be down there.
Buffalo, right. It's wonderful.
Yeah, it's great. Awesome. Well, Brigid, thanks again so much for your time. I truly appreciate it. And I know this was great information. So I'm really hoping that lots of people take advantage of this, and I will put your contact info in the description. So anybody that wants to get a hold of Brigid, absolutely please do and should. Thank you, Brigid.
Thank you, Missy. This has been a lot of fun. I'll see you soon.
All right, that sounds great. Take care.
You too.
Thanks.